Hi everyone, in this video we will discuss some important case laws on intellectual property rights. This is part 2. The first case is Bayer Corporation versus Union of India 2014 Bombay High Court. Bayer Corporation obtained a patent for the cancer medication Nexavar, but the Indian Patent Office granted a compulsory license to Natco Pharma Limited, allowing them to produce a generic version of the drug. In addition to the license, the Patent Office imposed certain requirements on Natco, including the payment of royalties to Bayer, the donation of 6,000 fee doses to the public, local manufacturing of the medicine, and restricting its sale to India without allowing others to manufacture it. Meanwhile, Bayer continued to manufacture Nexavar at a higher price than the one offered by Natco. Dissatisfied with the decision of the patent's controller, Bayer took the matter to the IPAB and submitted an application which was rejected. Bayer then filed an appeal before the board, which also met with rejection. Bayer Corporation filed an appeal before the Bombay High Court, but the court upheld the Patent Office's authority to grant compulsory licenses, emphasizing the need to ensure affordable access to life-saving drugs for the general public. The Supreme Court later affirmed the judgment of the Bombay High Court. The next case is Yahoo Incorporated versus Akash Arora and another 1999 Delhi High Court. This judgment on IPR law in India dealt with the protection of intellectual property rights on the internet. The Delhi High Court ruled that a domain name serves the same function as a trademark and therefore deserves equal protection. The case involved the domain names of the plaintiff, Yahoo, and the defendant, Yahoo India, which were phonetically similar and identical. The court recognized that this could lead to confusion among internet users who might mistakenly believe that both domain names were connected or originated from the same source. The court further noted that the disclaimer used by the defendants was insufficient. In the online realm, disclaimers are not effective remedies for the use of similar or identical domain names. Additionally, it was irrelevant that the term Yahoo is a dictionary word. The name Yahoo had acquired distinctiveness and uniqueness through its association with the plaintiff. The Bombay High Court, in a related case, Rediff Communication versus Cyberbooth and another 2000 PTC 2009, also recognized the significance and value of a domain name as a corporate asset for a company. The next case is Bajaj Electricals Limited versus Gaurav Bajaj and another 2020 Bombay High Court. In this case, the plaintiff was a company incorporated as part of the Bajaj Group, a conglomerate of businesses and industries. The defendant, an individual, incorporated the word Bajaj into his own name. The defendant operated 2 electrical stores and a website using the name Bajaj. Furthermore, he used the expression powered by Bajaj on his product labels. The plaintiffs successfully established that their name had attained well-known status over several decades, entitling only them to its use and not the defendant or anyone else. The defendant claimed legitimate use of his own name, but the plaintiffs also proved the defendant's malicious intent in using the name on his product labels. By doing so, the defendant attempted to deceive consumers, leading them to believe that his products were endorsed by the Bajaj Group. The court recognized the valid arguments put forth by the plaintiffs subsequently issued an interim injunction against the defendant prohibiting the use of the trademark on their products and in their domain name. The next case is Marico Limited versus Abhijit Bansali, 2020, Bombay High Court. The defendant in this case was a social media influencer who operated a YouTube channel. In one of his videos, he made a derogatory comment about Parachute Coconut Oil, a product belonging to the plaintiff company. The plaintiff company had established a strong reputation in the market for the quality of their products and was concerned about the disparaging comments made about their product and the unauthorized use of their trademark Parachute. This unauthorized use amounted to trademark infringement as it violated the plaintiff's exclusive rights as the trademark proprietor. As a result, the plaintiff approached the Bombay High Court seeking an injunction against the defendant. The court, relying on the Trademarks Act 1999, interpreted Section 29 of the Act and concluded that the defendant had indeed infringed the plaintiff's trademark by using it without prior authorization in his video. Therefore, the court granted an interim injunction against the defendant and ordered the removal of the offending video. The last case is Sameer Vadekar and another versus Netflix Entertainment Services Private Limited, 2020, Bombay High Court. This lawsuit was filed on the grounds that the defendant had allegedly copied the plaintiff's literary work and adapted it into a web series without permission, thereby infringing the plaintiff's copyright. The plaintiff contended that there were significant similarities between his work and the web series and that he had previously shared his work with an individual associated with the defendant. As a result, the plaintiff claimed copyright infringement and sought an injunction to prevent the release of the web series. The Bombay High Court carefully examined both works and determined that the similarities were not substantial enough to establish the web series as a direct copy of the plaintiff's literary work. The similarities identified were primarily related to the concept and they didn't constitute copyright infringement. Additionally, the court ruled that the mere fact of the plaintiff having shared his work with an associate of the defendant was insufficient to establish a prima facie case of copyright infringement. Consequently, the application for an injunction was dismissed and the release of the web series was allowed. That's all for the day. Thank you for watching this video.